Hello and welcome. This webinar forms part of a series of webinars given by Mayer Brown's Global Employment and Benefits Group on the issues affecting employers who are planning a return to work or who are adjusting to carry on business in the current circumstances. It forms a part of Mayer Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. Mayer Brown's global COVID-19 response offers insight on and analysis of the virus's impact on business worldwide through the dedicated portal known as Responding to COVID-19, which can be accessed via the Mayer Brown website or by searching covid19.mayerbrown.com. We have designed the webinars so that they can function equally well as either an audio-only broadcast or accessed via a video link. We hope you enjoy the series.
Good morning and good afternoon to everyone. Thank you for joining today's webinar. My name is Tran and I'm a partner in Mayer Brown's Employment and Benefits practice here in Hong Kong. I'm joined today by my partner Jennifer Tam, and together we will address the key issues and risks that employers are grappling with on getting back to business. We held a webinar for multinational employers in May earlier this year, and this discussed the employment, benefit and mobility issues and risks at a global level, in particular highlighting Brazil, France, Germany, Hong Kong, the UK and the US. You can access this global webinar via the Mayer Brown COVID-19 portal, which we call Responding to COVID-19, which is available through the Mayer Brown website or by searching covid19.mayerbrown.com. This Hong Kong-specific webinar will now drill down into the details. This webinar is part of our 10-100 series, focusing on the top 10 issues that employers need to consider in the next 100 days. You can access the other webinars in this series over the coming weeks, which can be found via the Mayer Brown Responding to COVID-19 portal, available through the Mayer Brown website, or again, searching for covid19.mayerbrown.com. The 10 issues that Jennifer and I will be covering today are set out in the slide. We'll be looking at workplace health and safety, but not too much into workplace health and safety, as most of you will already know your obligations on workplace health and safety, potential cost containment measures, employment contract variations, looking at issues around agile and flexible working arrangements. Of course, employment ordinance obligations need to be considered, workplace discrimination and harassment, as well as data privacy, termination of employment, continuing to monitor travel restrictions and quarantine requirements, and for those who are looking at government support, looking at the application for the second tranche of the ESS. Workplace health and safety of employees will remain high in the list of priorities for employers. Although the government has gradually relaxed social distancing rules, employers should remain vigilant and not be complacent in discharging their workplace health and safety obligations to their employees. Employers have statutory obligation under the Occupational Safety and Health Ordinance to take reasonably practical steps to ensure the workplace health and safety of their employees. Very quickly, to comply, employers should carry out the necessary risk assessments, work out what is reasonably practicable or what reasonably practical steps may be taken, and then implement those steps. Many employers have already dealt with workplace health and safety issues and are familiar with them. Therefore, I won't dwell on them. The point here is not to be complacent on workplace health and safety. Next, I'll talk about cost containment. The times ahead are uncertain. COVID-19 has had a significant impact on many industries and employers. A number of our clients have inquired about potential cost containment measures as they try to plan for the uncertain times ahead. Some have done this to know their options, even though they have not implemented any of those options at this time. Others have had to take one or more measures to try and stay afloat. Broadly speaking, the options available to an employer include unpaid leave, salary reduction and benefits restrictions, bonus adjustments or deferrals, reducing working hours, requiring employees to take annual leave, and termination of employment. I'll just talk briefly carefully about each of those options. So starting with unpaid leave. At its simplest, unpaid leave is where the employee takes leave and doesn't have to work, but at the same time is also not paid their usual salary. It is a way for the employer to reduce some of its wage bill. There are a number of ways of structuring unpaid leave. It can be a one-for-one arrangement where the days off are linked directly to the reduction in wages. So if the employee takes 4 weeks unpaid leave, their monthly wages are reduced proportionately by 4 weeks in the month the employee takes the leave. So if the 4 weeks coincide with a calendar month, then the employee will not be paid wages for the month the employee takes the unpaid leave. Alternatively, and another way of structuring the unpaid leave arrangement is to allow an employee to choose to take, say, the 4 weeks off, whether consecutively or on individual days over a set period, say 4 months. During those 4 months, the employee's wages are reduced by 25% each month, being the 4 weeks' wages spread over the 4 months. The advantage of this option is that the employee will continue to receive some wages over the 4 months to help the employee to continue to pay bills and things like that, instead of taking a significant hit in just 1 month. Another advantage is if the employer has applied for the ESS, the employer will need to maintain their March 2020 headcount for the month of June, July, and August, can only take into account employees who are paid. So having an employee paid during those months, albeit at a reduced rate, will help the employer to discharge their ESS undertaking, not to reduce headcount. The downside of this approach is that the 4-month period may need to be disregarded in calculating daily average wages under the employment ordinance for the purpose of working out things like statutory holiday pay and statutory annual leave pay. This can increase the amount of the DAW, the daily average wages. We will talk a bit more about DAW later in this session. Another point to note is that if a statutory holiday falls within a period of unpaid leave, then statutory holiday pay, calculated in accordance with the employment ordinance, is still payable, even though the other days around the statutory holiday are unpaid. An employer will need to ensure that statutory holiday pay is paid because it's an offence otherwise. Whichever option is chosen, it is important that the change is appropriately documented. The agreement or the consent of the employee will usually be required, as it represents a significant benefit that will be changed under the contract of employment. We'll talk a bit more about the options for obtaining consent and variation to the contract of employment a bit later. Another way to reduce employment costs is to reduce salary and benefits. So salary reduction or benefits restrictions are also measures which we've seen some employers adopting in the past few months. Again, there are a number of options with salary reductions and benefits restrictions. For example, the reduction can be temporary or it can be permanent. Some of the legal issues that an employer will need to bear in mind are, one, consent of the employer will, in most cases, be required. Another issue is legal consideration will also be required to be provided by the employer to support the agreement to reduce salary. Legal consideration is any benefit provided by the employer or any detriment agreed to be suffered by the employer in exchange for the employee's agreement to reduce their salary. This can be a one-off ex gratia payment by the employer or the granting of an additional day of leave. It doesn't have to be a significant benefit to the employee, but it needs to be something. As with unpaid leave, salary reduction may have an impact on the calculation of an employee's wage-based entitlement under the EO. Because statutory holiday pay is calculated based on the DAW over the preceding 12 months, and salary has been reduced in the month that the statutory holiday falls, there may be less wages available to discharge the obligation of paying statutory holiday pay. Therefore, the employer may need to make a top-up payment to ensure that it has paid the employee not less than the statutory rate. An employer will not be able to agree to pay the employee less than his or her statutory entitlement. Any agreement which reduces any employees or seeks to reduce any employee's entitlement under the EO will be unenforceable. Another option is to see if the employer can defer large payments like bonuses. If the bonus has been awarded, if the bonus that has been awarded is a contractual entitlement, then the employer will need the agreement of the employee to defer the payment of last year's bonus. If the bonus is truly discretionary in nature and the employer has not awarded the bonus to the employee, then there may be room for the employer to adjust the amount of bonus payable and the time for the payment of the bonus. Of course, you will need to look at the terms of the bonus scheme and the contract of employment. If the bonus is contractual in nature, the employer will need to comply with its contractual obligations unless the employee agrees to any proposed variation. There is a question mark over whether an employee can agree to defer the payment of an end-of-year payment under the EO beyond when it ought to have been paid, as that would be reducing rights, benefits, and entitlements under the EO, which would fall foul of the anti-contracting out section of the EO, that is section 70 of the EO. An end-of-year payment is any annual or contractual payment or bonus not ex gratia in nature or payable only at the discretion of the employer. There are certain statutory obligations under the EO to pay an EOYP or end-of-year payment within a specified period. Next, I want to talk about reducing working hours for employees who are paid on an hourly basis or casual workers. The employer may ask them not to come in or not assign work to them or assign duties to them. The reduction in the number of working hours may trigger payment or the payment of statutory severance pay in certain circumstances. An employee who is employed under a continuous contract of employment for not less than 24 months is entitled to statutory severance pay if he or she is laid off. Now, if an employee's remuneration depends on his or her being provided with work by the employer, that employee shall be taken to be laid off if the total number of days on which no work is provided and no wages is paid exceeds half of the total number of normal working days in any 4 consecutive weeks, or 1/3 of the total number of normal working days in any 26 consecutive weeks. So you may end up in a situation where, as an employer, you may need to pay statutory severance pay if the criteria are satisfied, even if the employee remains employed and even if the employer hasn't taken steps to terminate that employee's employment. Just dealing with the last 2 points, taking annual leave. Now, requesting an employee to take annual leave is an option, although it doesn't necessarily reduce costs because you'll still need to pay the employee annual leave pay during the period of annual leave, but it does reduce the provision for annual leave on the company's accounts. So in that respect, it reduces the bank of liability. From a practical standpoint, or from a resourcing perspective, an employer may want or will want an employee to take leave when business is slow so that employees are not taking leave when the business picks up. There is a process for granting annual leave under the Employment Ordinance. In respect of statutory annual leave, the employer must consult with the employee on the days on which to take annual leave, and if agreement can't be reached, then give the employee not less than 14 days notice of the days on which the employer wants to grant or will grant the annual leave. Then the last point is termination of employment. Now, terminating the employment of an employee generally is the last resort in terms of reducing costs, but it does happen. We'll talk a bit more about termination later in this session, so I won't deal with it here. The first 3 scenarios that I mentioned, that is the unpaid leave, salary reduction, and bonus adjustments, typically require the consent of the employee. And we'll now take a little closer look at what is required to change the contract of employment. I'll hand you over to Jennifer to talk about that.
Thank you, Hong. The third issue on the list is contract variation. The basic legal principle is that any variation of a contract of employment requires the mutual agreement of both parties unless there is an express term in the contract enabling one party to vary unilaterally the contract. In the absence of a term allowing the employer to vary unilaterally the contract of employment, the employer must obtain the agreement of the affected employee to the proposed variation. Failure to do so may result in a breach of contract by the employer. Even if the contract contains an express variation clause, the employer's power to vary is not unfettered. Among other things, the employer must exercise its power to vary rationally and not capriciously. That is, the employer must have sufficient grounds for the proposed change. What would be considered sufficient and not irrational or capricious would depend on all the facts and circumstances. The level of an employee's salary and benefits are key terms of employment. Any proposal to reduce the salary or benefits of an employee will normally require the express consent of the employee to vary the contract of employment. Any agreement to vary is like any other agreement and requires at least 1. An offer, 2. Acceptance of that offer, 3. That there is certainty around the terms of the agreement, and lastly, legal consideration to support the agreement. What can sometimes be difficult to identify is the legal consideration that is provided by the employer, especially where the employee is being asked to suffer a detriment like a salary reduction or undertake a period of unpaid leave, and the employer is not providing anything to the employee in return. An agreement unsupported by legal consideration will be unenforceable, even if the employee signs the agreement. Given that the consequences of getting things wrong can be quite serious, for example, it is an offense to unlawfully deduct from wages and not pay wages on time, and the limitation period for unpaid wages claims can go back 6 years, it is important to get it right where the variation affects rights that are protected under the Employment Ordinance. As to getting the consent, generally speaking, an employee will only consent to a reduction in his contractual benefits if he or she is incentivized to do so. There is generally a carrot or a stick or both approach to obtaining consent from the employee. The carrot option will involve providing some form of incentive to entice the employee to agree to the change to the contract of employment. For example, an offer of additional leave in return for the agreement to a salary reduction. The stick option involves imposing some form of detriment on the employee. An extreme example would be to terminate the existing contract of employment and offer a new contract with the revised terms or conditions. This is a very drastic step to take and can be quite an expensive exercise. The carrot and stick options are not mutually exclusive, and they may be implemented together in varying degrees. Any agreement made with the employees should be recorded in writing to minimize the risk of any dispute in the future. You should also allow time for the employee to consider the proposed amendments, and no agreement should be made under duress. Otherwise, this may give rise to various claims such as constructive dismissal claim, unreasonable variation claim, or unreasonable dismissal claim under the Employment Ordinance. There is no statutory obligation to consult the employee or the staff union before making any proposal for variation. But if you have any such contractual obligation to consult, then you need to comply with your contractual obligations. If the cost containment measures applies to a certain group of employees instead of across the board, then make sure that the reason for the proposed amendments to the contract of the relevant employees have nothing to do with the protected attributes under the Anti-Discrimination Ordinance. Earlier this year, employers who allow their employees to work from home have experienced difficulties to obtain the employees' consent to any cost containment measures or even to serve notice of termination if the employee is locked down outside Hong Kong. If you are making other changes to the employment contract, you may also consider introduce a service of notice provision, which provides that notice, say by emails, is valid notice, and a electronic signature provision, which provides that an email confirmation constitutes a binding acceptance and agreement in the contract. These clauses will enhance and facilitate communication in the future. Turning now to number 4 on our list of 10, that is looking at the changing nature of work in light of the experience thrust on us by COVID-19, that is looking at flexible and agile working. Businesses that didn't think about flexible and agile working before COVID-19 were forced to think about this when social distancing requirement meant many had to work from home. Of course, there are some businesses where flexible and agile working just won't work, like cleaning businesses and some of those in the hospitality industry. But for those employees whose work primarily involves having access to a computer, internet, and a phone line, it was quickly discovered that they did not necessarily need to be in the office to perform the work. And for some employers, working from home worked out better than what they had feared. So our fourth point is to consider possible flexible and agile working arrangements going forward, if this works in your industry. By flexible and agile working, an employer can look at changing the hours worked, the times when the employee is required to work, and the location where work is performed, for example, working remotely. Within these three categories are a wide range of possible work patterns, for example, annualized hours, compressed hours, flexi time, home or remote working, job sharing, self-rostering, shift working, staggered hours, and term time working. So what are the legal issues around flexible working? 1. Workplace health and safety. Even if the workplace is at home, the employer is still required to take all reasonably practical steps to ensure the workplace health and safety of the employee. 2. Complying with the obligations under the employment ordinance. If the employee is employed under a continuous contract of employment, you will need to provide them with the relevant benefits and entitlements, and paying them not less than the amount required under the EO. 3. An employer should be careful when assessing requests for flexible or agile working and not to engage in any unlawful discrimination under the anti-discrimination ordinance. The protected attributes under the current anti-discrimination ordinances are sex, marital status, pregnancy, disability, race, and family status. The breastfeeding discrimination will come into force in June 2021. There are two types of unlawful discrimination, direct and indirect. A man could bring a claim for direct sex discrimination if his request to work flexibly was not considered seriously, whereas a similar request made by a woman would have been given proper consideration. Claims such as this are less common. What is more common is indirect discrimination. Indirect discrimination occurs where a requirement or condition is applied to a person with a protected attribute, and it is applied equally to a person without that particular attribute, but has a disproportionate effect on a particular group of persons because of the attribute. In addition, this requirement or condition cannot be shown to be justifiable, and its application operates to the person's detriment. When considering the meaning of justification, the court will consider whether the objective was legitimate, whether the means used to achieve the objectives are reasonable, and whether the conditions are justified when balanced on the principle of proportionality between the discriminatory effect upon the applicant's group and the reasonable needs of those applying the conditions. Guidance from the English courts indicates that the courts will try to put themselves in the shoes of the employer and consider the commercial rationale. However, if there is little impact on the business during the impact, even if most of the workforce work remotely, it may be more difficult for the employer to justify the requirement for the employees to work in the office in the future. Below are some do's and don'ts when it comes to flexible or agile working. Let's start with what we should be doing. 1. Have a clear written policy in relation to flexible working. The policy may include, for example, what does working from home mean? What are the working hours? Are the employees required to record the hours worked for the purpose of the minimum wage ordinance? 2. Take steps to ensure that all employees are aware of the policy so that the employees' obligations are clear. 3. In assessing any application for flexible working, start from a positive perspective. Ask, how can we do this, rather than how can we avoid this? Courts are often critical of employers who approach a request to work flexibly by considering why it won't work, rather than how any difficulties could be overcome. If the employee's proposed arrangement is not acceptable, consider and propose alternatives. The more flexible the employer can be in suggesting alternative arrangements, the greater the chance of justifying its decision. If there is a reluctance to agree to a permanent change, consider a temporary change or a trial period. Explain and discuss the difficulties with the employee. 4. Document the new arrangement carefully. Remember that a lack of clarity leads to disputes. Often, the original request to work flexibly would have evolved through a discussion process, and the terms ultimately reached may not be exactly as originally requested. As the changes agreed will be a contractual variation to the employee's employment contract and will be permanent, the employer should either issue a new contract setting out the terms as finally agreed, or at least issue a letter setting out the new terms and expressly amending the employment contract with effect from the start date. This should be countersigned by the employee to acknowledge the acceptance and agreement. 5. Document all reasons for declining a flexible work request carefully. An employer should consider all the evidence available to suggest that it would not work and document this. If a request is rejected, the better the reasons for the employer's response, the more likely it is to be accepted by the employee. So what are the don'ts? 1. Don't dismiss application for flexible work without considering it. The world and technology change, so what may have been impossible 5 years ago may now be possible. 2. Don't be inconsistent. Employers should aim to ensure that flexible working requests are recorded and preferably processed in a way that ensures that decisions are made consistently across the organization. Finally, don't question whether or not the employee should be looking after a child or relative. Don't say, for example, can't your maid, mother, father, wife, husband look after the baby? If the employee has care of his or her child, which is an immediate family member, then the employee is protected. He or she is a person with a family status under the Family Status Discrimination Ordinance, whether or not there is someone else who could care for the child instead. halfway through our list now. Number 5 is being mindful of the employer's obligation under the Employment Ordinance. Employees who are employed under a continuous contract are entitled to certain benefits under the Employment Ordinance, such as rest day, paid annual leave, paid statutory holiday, sickness allowance, etc. Generally, an employee who has worked 18 hours a week for 4 or more consecutive weeks are employed under a continuous contract of employment. This is commonly known as the 418 rule. In addition to the actual hours worked, certain hours in which the employee has not worked should also be taken into account in determining whether the employee satisfies the 418 rule. These hours not worked include absence due to sickness or injury in excess of 48 hours with medical certificates, and absence by law, mutual arrangement, or the custom of the trade, business, or undertaking. The employee is regarded as continuing in the employment of his employer for any purpose. For example, if an employee agrees to a period of unpaid leave of 4 weeks, which is a period of agreed absence, the period of unpaid leave will not break the continuity of employment, notwithstanding that the employee did not actually perform work. Further, if a statutory holiday falls during the period of unpaid leave, and the employee has been employed under a continuous contract for not less than 3 months before the statutory holiday, the employee is entitled to statutory holiday pay. The statutory wage-based entitlements linked to continuous contract of employment are end-of-year payment, statutory holiday and statutory holiday pay, statutory annual leave and statutory annual leave pay, sickness allowance, maternity or paternity leave and leave pay, statutory severance pay, long service pay, and payment of wages in lieu of notice. The wage-based entitlements under the Employment Ordinance are calculated by reference to the daily average wages, DAW, or the monthly average wages, MAW, of the employee. In computing the employee's DAW or MAW, the Employment Ordinance requires an employer to average an employee's wages over the preceding 12 months. However, the employer must disregard any period for which the employee was not paid his wages or full wages by reason of certain leave days, including any leave taken by the employee with the agreement of the employer. We discussed just now an unpaid leave arrangement. Depending on how it is structured, there may be a different impact when calculating DAW or MAW under the Employment Ordinance. If an employee agrees to take a defined period of unpaid leave, say 5 days, the days on which the employee is on paid leave, i.e. the 5 days, should be disregarded in calculating the DAW or MAW. Whereas, if an employee agrees to, say, a 25% reduction in the monthly wages over 4 months in return for 4 weeks leave that he or she can take any time during those 4 months, then the reduced wages paid for the 4 months and those 4 months should be disregarded in calculating the DAW. Another point to note is the minimum wage ordinance. An employee should be paid not less than the statutory minimum wage, which is currently at $37.50 per hour. Payment for time that is not hours worked should not be included as wages paid in the relevant month. The next issue we want to talk about is workplace discrimination and harassment. We will focus on the discrimination and harassment issues under the DDO, Disability Discrimination Ordinance. DDO prohibits the less favorable treatment of an employee on the ground of disability. A disability is defined very broadly under the DDO. It includes a disorder, illness, or disease that affects a person's thought process, perception of reality, emotions, or judgment, or that results in disturbed behavior, as well as a disability that is imputed to a person. This is likely to cover someone you suspect of having the coronavirus, even if they don't actually have it. It is also unlawful if, on the ground of the disability of an associate of that other person, he treats him less favorably than he treats or would treat a person without such disability. An associate is generally anyone in a close relationship with the employee. So, it is unlawful disability discrimination if you treat an employee less favorably because his or herself has the coronavirus or is suspected of having the coronavirus, unless an exception applies. The most relevant exception is the infectious disease exception under Section 61 of the DDO. This section provides that it is not unlawful to discriminate against another person with a disability if A, that person's disability is an infectious disease, and B, the discriminatory act is reasonably necessary to protect public health. COVID-19 is an infectious disease. So the question to be assessed is whether the act is reasonably necessary to protect public health. Asking an employee who has just returned from areas with a large number of confirmed cases to self-quarantine, if the government has relaxed the quarantine arrangement, or requiring them to wear masks while in office would be reasonably necessary to protect the health of other employees in the same office. However, terminating the employment of that person solely because he or she has returned from those areas may not be. Another unlawful conduct under the DDO is disability harassment. Disability harassment means unwelcome conduct towards a person on account of his or her disability, or towards this person's associates, where a reasonable person, having regard to all circumstances, would have anticipated that the person with a disability would be offended, humiliated, or intimidated. Name-calling of employees with a disability is a common example of disability harassment. Employees who have the coronavirus or have close contacts with a confirmed case will be absent from work for some time, and other employees will need to cover them during their absence. These employees may become resentful and indicate their dismay towards the employee when he or she returns to work. They may isolate the employee or even make unreasonable demands. These sentiments and resentful conduct, if not properly managed, may give rise to claims for disability harassment. So what should employers do to minimize the risk exposure? First of all, you should have an appropriate anti-discrimination and anti-harassment policy in place. Provide employees with appropriate training on these policies and take appropriate action immediately in the event there may be a complaint or information coming to your attention which falls within the scope of the policies. An employer will be held vicariously liable for the action of an employee done in the course of employment, whether or not it is done with the employer's knowledge or approval. It is a defense available to the employer to a claim for vicarious liability if the employer can prove that it took such steps as were reasonably practicable to prevent the employee from doing that act or from doing, in the course of the employment, acts of that description. It is difficult to demonstrate this if the employer has not done at least the steps just mentioned. The next issue is data privacy. If you collect personal data of an employee, particularly sensitive data like health data, or those who visit your office, then you need to comply with the PDPO, Personal Data Privacy Ordinance. So that means issuing the appropriate PICs, making sure that the collection is adequate but not excessive, and only using the data collected for the purpose for which it was collected. So, if you ask your employee to see a doctor for the purpose of producing a medical report and the employee agrees, then you should also ask the employee to provide a consent to the doctor to release the medical report to you. There is an exception to the obligations under the PDPO relating to access to personal data and use, where the application of those provisions under the PDPO would be likely to cause serious harm to the physical or mental health of the data subject or any other individual. So, if the police come knocking, looking for the address of one of your employees who has escaped quarantine, then you may be able to disclose the employee's address. In that scenario, you will probably also fall under the crimes exception under Section 58 of the PDPO. Data security is also important. Adequate data security safeguards should be implemented to reduce the risk of unauthorized or accidental access to any sensitive medical or health data collected. There may be an increased risk of data breach as a result of working from home arrangements. For example, the employee may be using their own device while working from home, in which case employers should be cautious and vigilant about the security of internet connection to prevent any data leakage. I do not plan to spend too much time on the PDPO. You may have a look at the guidelines issued by the Privacy Commissioner on the obligations of the employer during the pandemic. Number 8 on our list is termination, one of the cost containment measures. Termination of employment in Hong Kong can be a relatively straightforward process. An employer normally can terminate the employment by giving the requisite notice to the employee or by making payment of wages in lieu of notice. Summary dismissal in the event of gross misconduct is another way to terminate an employment, but the employer has the burden to prove that summary dismissal is justified in the circumstances. Employees are more likely to sue if they are summarily dismissed in order to clear their names and to recover the terminal payment. Non-renewal of a fixed-term contract is another way to end an employment relationship. A fixed-term contract ends automatically upon the expiry of the fixed term. Neither party is required to give notice to terminate the contract on expiry of the term. While the termination process can be relatively straightforward, there are certain statutory prohibitions on termination. It is unlawful to terminate the employment of an employee in the following circumstances. 1. Termination of an employee while on a sickness days on which statutory sickness allowance under the Employment Ordinance is payable unless summary dismissal is justified. 2. Termination of a pregnant employee. It is unlawful to terminate except by summary dismissal or during the first 12 weeks of the probation period. It should also be noted that the employer must withdraw the notice of termination if the employee gives notice of pregnancy immediately after being informed of the termination. 3. It is unlawful to terminate an employee or give notice to terminate an employee who is entitled to receive compensation under the Employees' Compensation Ordinance, that is, an employee who has sustained a work injury, before certain certificates are issued by the Labor Department. The only exception to this prohibition is with the consent of the Commissioner for Labor. In my experience, the Commissioner for Labor rarely gives such consent. Finally, it is unlawful to terminate due to unlawful discriminatory reasons. The protected attributes under the Anti-Discrimination Ordinance are sex, marital status, pregnancy, disability, family status, and race. Redundancy is a valid reason for termination. However, it should be noted that it is not an exception to any of the statutory prohibitions on termination which I mentioned just now. Here are some points to note before implementing any termination decision. 1. You can terminate the employment of an individual employee even if you are granted the first tranche of the wage subsidy under the employment support scheme. However, if you do not manage to recruit a replacement during the subsidy period and the headcount falls below the number in March, you will need to repay the government a portion of the subsidy. 2. Redundancy is a valid reason for termination. Yet, you must ensure that the reason for selecting certain positions to be made redundant has nothing to do with the protected attributes of the employees under the anti-discrimination ordinances. 3. If any statutory prohibitions on termination which I mentioned just now applies, be patient and wait until the statutory prohibitions cease to apply before proceeding with the termination. Alternatively, an employer can attempt to negotiate a mutual separation with the employee where the parties agree that the employment ceases by mutual agreement instead of termination by the employer. An employer will need to provide legal consideration, that is something on top of the employee's statutory and contractual entitlements on cessation of employment, in order to entice the employee to agree to the mutual separation and for the agreement to be enforceable. 4. There is no statutory obligation in Hong Kong for an employer to consult the employee, the staff union, or the government before any redundancy exercise. However, if you have any contractual obligations to consult, then of course you need to comply with your contractual obligations. The second last issue on the list is to monitor the development of the travel restrictions and quarantine measures implemented by the government both in Hong Kong and in other jurisdictions. Our Global Travel Navigator can be a quick reference guide for you, but you should always check the official announcement. Although we haven't seen international travel open up and do not anticipate it anytime soon, when it does open up, workplace health and safety issues will need to be considered in more detail to the extent that they have not already been considered. Putting everyone on the same page and letting the employees know what the employer is doing may help reducing nervousness in the workplace given the concerns about the coronavirus. In this regard, you may consider having in place a policy or directives for employees who travel abroad, both for work and leisure, or employees who live with someone who has traveled or come into contact with those who have traveled. These policy or directives will help employers to keep track of the whereabouts of the employees and where they have been. You can't keep them or any other co-workers out of harm if you don't know where they are or have been. You will also need to provide a safe platform for the employees to raise concern and report issues. If those who report are treated with contempt or stigmatized, you are not going to get much reporting. Here comes the last issue, the second tranche of the wage subsidy under the employment support scheme. The government provided a wage subsidy to help dealing with the negative economic impact of the coronavirus. The objective is to retain employment. The application for the first tranche of the subsidy for June, July, and August 2020 closed the week before. The second tranche is for the 3-month period from September to November 2020, and the government aims to disburse the subsidy in September. Eligible employers can apply for the second tranche of the subsidy, even if they did not apply for the first tranche. The details of the second tranche of the ESS are still being worked out, so stay tuned on the development.
This brings us to the end of this webinar. Thank you for joining us. We hope you found it helpful, and please do get in touch if you have any follow-up queries. As mentioned at the beginning, this webinar is part of our 10-100 series, focusing on the top 10 issues that employers need to consider in the next 100 days. You can access the other webinars in this series over the coming weeks, covering France, Germany, and global mobility via the Mayer Brown Responding to COVID-19 portal, which is available through the Mayer Brown website or by searching covid19.mayerbrown.com. If you would like similar information on another jurisdiction, please let us know by contacting your usual Mayor Brown contact or Jennifer or myself. We work with a well-established network of law firms in a wide range of jurisdictions, and we'd be happy to explore a joint seminar if there is sufficient interest. Thanks again for listening, and we look forward to you joining our future webinars.
Thank you for listening. We hope you found this useful. This series forms part of Mayor Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. If you have any questions, please get in touch with any of the speakers or your usual contact at Mayor Brown, and we will be happy to follow up with you directly. For the latest COVID-19 related legal developments, please do visit our dedicated portal called Responding to COVID-19, which is available through the Mayor Brown website.